5 seconds to go. Start. Courts would not thwart any investigation into the cognizable offences, para. However, in cases where no cognizable offence or offence of any kind is disclosed in the first information report, the court will not permit an investigation to go on. Para. The power of quashing should be exercised sparingly with circumspection, in the rarest of rare cases. The rarest of rare cases standard in its application for quashing under section 482 CRPC is not to be confused with the norm which has been formulated in the context of the death penalty, as explained previously by this court. While examining an FIR complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR complaint. Criminal proceedings ought not to be scuttled at the initial stage. Quashing of a complaint FIR should be an exception and a rarity than an ordinary rule. Para. Ordinarily, the courts are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres of activities. The inherent power of the court is, however, recognized to secure the ends of justice or prevent the above of the process by section 482 CRPC. Para. The functions of the judiciary and the police are complementary, not overlapping. Save in exceptional cases where non-interference would result in miscarriage of justice, this court and the judicial process should not interfere at the stage of investigation of offences. Extraordinary and inherent powers of the court do not confer an arbitrary jurisdiction on the court to act according to its whims or caprice. Para. The first information report is not an encyclopedia which must disclose all facts and details relating to the offence reported. Therefore, when the investigation by the police is in progress, the court should not go into the merits of the allegations in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that the complaint FIR does not deserve to be investigated or that it amounts to abuse of process of law. During or after investigation, if the investigating officer finds that there is no substance in the application made by the complainant, the investigating officer may file an appropriate report summary before the learned magistrate, which may be considered by the learned magistrate in accordance with the known procedure. Para. The power under section 482 CRPC is very wide, but conferment of wide power requires the court to be cautious. It casts an onerous and more diligent duty on the court. However, at the same time, the court, if it thinks fit, regard being had to the parameters of quashing and the self-restraint imposed by law, more particularly the parameters laid down by this court in the cases of R.P. Kapoor Supra and Bhajan Lal Supra, has the jurisdiction to quash the FIR complainant, and when a prayer for quashing the FIR is made by the alleged accused, the court, when it exercises the power under section 482 CRPC, only has to consider whether or not the allegations in the FIR disclose the commission of a cognizable offence and is not required to consider on merits whether the allegations make out a cognizable offence or not, and the court has to permit the investigating agency police to investigate the allegations in the FIR. Para. We will now, carefully scan the application filed by the respondent herein, which was forwarded for investigation under section 156(3), CRPC to consider whether the appellant is justified in taking up the contention that the allegations raised thereunder did not contain the ingredients to constitute the alleged offences, or whether the respondent had made out a prima facie case for investigation. Stop. In that regard, it is worthwhile to take note of the fact that the respondent herein has alleged commission of offences under sections 323, 384, 406, 423, 467, 468, 420 and 120b, IPC against the appellants. Stop. We will refer to the ingredient to constitute such offences to consider the said question. Stop.